Virtual Lesson 4.3, Organizing the Workforce. The Need for Organization. In the early 1800s, employees were generally either farm hands or skilled craftspeople providing goods or services out of small shops. With the technological revolution gaining momentum in the mid-1800s, many skilled workers found themselves replaced by machines. With this decreased demand for labor, employers enjoyed a much greater position of power and could foist unfair and unsafe work conditions on desperate employees. At that time, the employer-employee relationship was governed by master and servant common law, and as the label implies, little respect was afforded to the rights of employees. An individual worker was vulnerable because there was always someone who was more desperate for work and willing to take on the unpleasant terms being offered. This motivated skilled workers in particular trades to form trade unions that would bargain collectively with employers in an attempt to protect their jobs, wages, and working conditions. The emergence of trade unions. Employers naturally resisted unionization, and labor relations in Canada have consequently been adversarial in nature. Most employers were much happier with the lopsided bargaining power that they had previously enjoyed. The primary tactic that trade unions would use to convince employers to meet their demands was to go on strike. This is the collective withdrawal of labor during negotiations. Employers argued that collective bargaining and strikes illegally restrained trade, rendering them less able to compete on the open market. This often led to criminal prosecutions, the imprisonment of trade union members, the dissolution of their organizations, and the loss of jobs. Despite the backlash, small local unions, consisting mainly of skilled craft workers, grew significantly in the 1860s. The ongoing struggle. In the 1870s, the 9-hour movement formed in Hamilton and other cities with the goal of limiting time at work to a 54-hour work week, which was generally taken as 6 9-hour days. In 1872, the typographic workers at the Toronto newspaper The Globe used strike action to gain a time-limited work week. Soon afterward, in June of 1872, the federal government passed the Trade Union Act, which legalized labor unions by nullifying the conspiracy offenses for union negotiators that had been included in the criminal code. Registering a trade union under the Act required members to agree to be liable for any damages to an employer's property during a strike. For this reason, few registered at first. In addition, the law did not yet require employers to bargain collectively with unions. They could refuse to hire union supporters or fire them freely. Over the years, union membership varied depending upon the economy and how desperate people were for work. Harsh conditions could still be found in many workplaces, and the federal and provincial governments typically sided with employers. During strikes, governments frequently called upon the police and the military to act against the workers. Despite the steady resistance, the number of strikes continued to increase in the late 1800s, and the general principle of workers' rights was recognized with the establishment of Labor Day in 1894. Amid concerns that frequent strikes were disrupting the economy, the federal government passed the Industrial Disputes Investigation Act in 1907. This legislation required that prior to the commencement of a legal strike, an investigation had to be conducted by a 3-person committee consisting of representatives of the workers, the employer, and the federal government. Since the government generally sided with the company, the employee's representative was usually overruled, and therefore the act effectively banned strike action until it was declared unconstitutional in 1925. The push for larger and more powerful unions. After World War I ended in 1918, many Canadian soldiers returned home with heightened expectations of their roles in society. They were not willing to resume working long hours for poor wages, as they had done before the war. This led to a movement in Western Canada to form the One Big Union, comprised of both skilled and unskilled workers from all industries. The primary purpose of the OBU was to initiate a general strike to obtain fair wages, the right to collective bargaining, and the guarantee of safe workplaces. Employers who were opposed to the formation of the OBU suggested that it shared communist ideals with the Bolshevik Revolution, which had recently taken place in Russia in 1917. The Winnipeg General Strike. In May of 1919, over 30,000 workers in Winnipeg went on strike to support building and metal trade workers who had been denied fair negotiations by their employers. In June, the federal government ordered the arrest of 10 members of the Central Strike Committee of the Winnipeg Trades and Labor Council, which had been formed to organize the strike. After news of the arrests got out, angry labor supporters took to the streets to demonstrate. Then, on Bloody Saturday, June 21, when police were called in to break up a parade of strikers, a violent clash broke out resulting in 2 deaths. The general strike ended a few days later with the workers failing to win any of the rights they had been seeking. Although the Winnipeg General Strike was a failure in and of itself, it did lead to the important realization that real change would only come with labor law reform. J.S. Woodsworth, who had been one of the organizers of the strike, was eventually elected to Parliament. He was one of the founders of the Cooperative Commonwealth Federation, or CCF, and was chosen as its first leader in 1932. He, along with 6 other CCF candidates, were elected to their first term in the House of Commons in 1935. The CCF would later become the New Democratic Party in 1961. Recognition during World War II. In contrast with the desperation of workers during the Great Depression, the demand for soldiers and for factory workers during the Second World War actually created a labor shortage. In 1943, amid numerous strikes and widespread labor unrest, Ontario passed the Collective Bargaining Act, which was really the first time the provincial government had officially recognized unions and took steps to facilitate collective bargaining. Under the Act, disputes that could not be resolved by the collective bargaining process were to be settled by the Ontario Labour Court, a branch of the Supreme Court of Ontario. This type of legislation ensured that labor concerns and issues could no longer be ignored. In 1944, the Federal Cabinet passed Order in Council PC 1003, which finally abolished the common law doctrines of conspiracy and restraint of trade, which had been used against trade unions. PC 1003 contained numerous rights and remedies for the advancement of unions and is considered to provide the framework of labor rights in Canada. However, it was only actually in effect for a few years. After the war, the provinces joined forces to have it abolished, arguing that it had been wartime legislation that actually dealt with provincial matters. Then, in 1948, each province passed its own legislation containing similar provisions. In Ontario, it was the Labour Relations Act. The evolution of labor rights. After the war, unions continued to fight for wage increases, industry-wide bargaining, and union security. Industry-wide bargaining included the goals of having all workers within an industry represented by one union that would negotiate for standard wages and working conditions. Union security included the requirement that a company should recognize a union where a majority of the workers desired one, as well as issues of union maintenance such as compulsory membership and the automatic deduction of union dues from paychecks, otherwise known as the check-off system. The Rand Formula. Union security issues made headlines in 1945 with the 100-day strike at the Ford Motor Company plant in Windsor. The union wanted compulsory union membership and the check-off system, which had already been in place in Ford plants in the United States. When talks broke down, the workers created a blockade of automobiles around the plant and throughout the streets of Windsor, effectively shutting down the city. The union and the company eventually agreed to binding arbitration. In other words, the settling of the dispute by an impartial third party. The federal government then appointed Supreme Court of Canada Justice Ivan Rand to do the job. His ruling, now known as the Rand Formula, included his assertion that all workers represented by a union should be required to pay union dues whether or not they had decided to join the union. This recognized the fact that those who had not supported or paid for union efforts had still benefited from them. Mr. Justice Rand also recommended the checkoff system to ensure that these dues were paid. In return for union security, it would be understood that the unions undertook not to strike while a collective bargaining agreement, or CBA, was in place. Illegal wildcat strikes, which occurred during the term of a CBA, could result in fines and the loss of checkoff privileges. Labor relations legislation. Historically, there were two parties to any labor negotiation, the employees and the employer. With the advent of unions, there were then three parties to these negotiations. Trade unions are legal entities with their own rights and responsibilities, which are set out in their constitutions and bylaws, and in various statutes. The relationships between unions and their members, and between unions and employers, are governed by labor relations legislation. In Ontario, the vast majority of employers and employees are governed by the Provincial Labor Relations Act. Workplaces that are federally regulated, such as banking, transportation and communications, and First Nations activities, are governed by the Canada Labour Code. The Ontario Labour Relations Board, or OLRB, is an independent tribunal that adjudicates matters that are governed by these acts. The Labour Relations Act. Ontario's Labour Relations Act includes regulations governing the certification of unions to act as bargaining agents for a group of workers, procedures for the negotiation of collective agreements, items that can be included in a collective agreement, guidelines for the operation of collective agreements, unfair practices by employers and employees, and regulations regarding work stoppages. Certification requires that at least 40% of employees in the bargaining unit are members of the union. A majority of the employees must then show support for the union in a vote held by the board. Once a union is certified, the employer can no longer negotiate directly with individual workers. Collective bargaining. With the union in place, it must then negotiate a first contract with the employer, which will remain in force for 2 years. It will include the settlement of important issues such as wages, hours of work, working conditions, and possibly insurance and pension benefits. The Labor Relations Act requires the parties to bargain in good faith, meaning that they must demonstrate the intention of reaching an agreement. However, if negotiations break down, the Act also provides for conciliation and mediation to assist. Conciliation involves government-appointed officers who meet with the parties separately to help them reach an agreement. If the conciliator or conciliators are not successful, then the Ontario Labour Relations Board may facilitate mediation or arbitration, which involves a meeting directed by a third party that is aimed at resolving the remaining issues. Strikes and lockouts. If the above-mentioned mechanisms fail, and the parties are still unable to reach an agreement after 14 days, they can resort to a legal strike or lockout. These are economic sanctions designed to put significant pressure on the other party. Strikes and lockouts are damaging actions that are prohibited during the term of a collective agreement. In Ontario, employers may hire replacement workers during a strike or lockout, but some jurisdictions, such as Quebec and Canada, in industries covered by the Canada Labour Code, ban the use of replacement workers, often referred to as scabs by union supporters. Although legal in Ontario, many employers avoid hiring replacement workers during a strike or lockout because it tends to create more tension and bitterness between the parties, making the negotiation process even more difficult. A union may also organize a picket line at a particular workplace during a strike. Picketing accomplishes two main objectives. Firstly, it helps to communicate the worker's position to the public, which can increase the pressure felt by the employer. And secondly, the picketers can impede the normal operations of the employer by delaying or preventing people or shipments from entering the workplace. In some cases, picketing may become so problematic that the police or government become involved. The picketers and organizers may then face charges or be legislated back to work. In all cases, though, the rights of the union to demonstrate and communicate its message must be weighed against the right of the employer to conduct its business and possibly the public need that the employer is meeting. Other union actions. It is illegal to stage a strike during the term of a collective agreement. However, disgruntled employees can still take action by working to rule. This means that they strictly adhere to their responsibilities as laid out in the collective agreement, but refuse any other duties that they would normally perform. When these informal duties are not carried out, the workplace may become much less efficient. Union leaders and workers who participate in work to rule run the risk of having the action interpreted as a wildcat strike by the OLRB, which could then impose fines. Grievances. Disputes that arise while a collective agreement is in place are called grievances. In Ontario, the Labour Relations Act requires the parties to a grievance to submit their dispute to binding arbitration. Such disputes may be filed by individual workers or by the union on behalf of the workers if it feels that the general rights at stake must be protected. Common grievances include dismissal, layoff, or a detrimental change in working conditions. Declining numbers. In recent years, the number of union members in Ontario and some other provinces has been declining. This has been due to a number of factors, including the relocation of factories and offices to the United States that followed free trade, the replacement of assembly line workers by robots and computers, and government actions such as weakening labor legislation and privatizing government services that had previously been provided by unionized civil servants. Any move away from unionization is generally for the goal of removing restrictions to trade and increasing profitability.